I could go on to read Justice Stevens, whom Justice Ginsburg and Justice Breyer joined dissenting, the Bush versus Gore decision. The Constitution assigns to the states the primary responsibility for determining the manner of selecting the presidential electors. When questions arise about the meaning of state laws, including election laws, it is our settled practice to accept the opinions of the highest courts of the states as providing the final answers. On rare occasions, however, either federal statutes or the federal Constitution may require federal judicial intervention in state elections. This is not such an occasion. Federal questions that ultimately emerge in this case are not substantial. Article 2 provides that each state shall appoint in such manner as the legislature thereof may direct a number of electors. It does not create state legislators out of whole cloth, but rather takes them as they come, as creatures born of and constrained by their state constitutions. The legislative power in Florida is subject to judicial review pursuant to Article 5 of the Florida Constitution, and nothing in Article 2 of the Federal Constitution frees the state legislature from the constraint in the state constitution that created it. Moreover, the Florida legislature's own decision to imply a unitary code for all elections indicates that it intended the Florida Supreme Court to play the same role in presidential elections that it has historically played in resolving electoral disputes. The Florida Supreme Court exercise of appellate jurisdiction, therefore, was wholly consistent with, and indeed contemplated by, the grant of authority in Article 2. It hardly needs stating that Congress, pursuant to Section 5, did not impose any affirmative duties upon the states that their government branches would be could violate. Rather, Section 5 provides a safe harbor for states to select electors in contested elections by judicial or other methods established by laws prior to election day. Section 5, like Article 2, assumes the involvement in the state judiciary in interpreting state election laws and resolving election disputes under those laws. Neither Section 5 nor Article 2 grants federal judges in any special authority to substitute their view for those of the state judiciary on matters of state law. So that's the interpretation of the legislation and the Constitution. I think the concurring opinion thought that it was an occasion where the Supreme Court could do just that. And the dissenters did not agree. Okay, next paragraph. Nor are petitioners correct in asserting that the failure of the Florida Supreme Court to specify in detail the precise manner in which the intent of the voter is to be determined rises to the level of constitutional violation. So nor does that happen. We found such a violation when individual votes within the same state were weighted unequally. But we have never before called into question the substantive standard by which a state determines that a vote has been legally cast. And there is no reason to think that the guidance provided to the fact finders, specifically the various canvassing boards, by the intent of the voter standard, is any less sufficient or will lead to results any less uniform than, for example, the beyond a reasonable doubt standard employed every day by ordinary citizens in courtrooms across this country. Admittedly, the use of differing substandards for determining voter intent in different counties employing similar voting systems may raise serious concerns. Those concerns are alleviated, if not eliminated, by the fact that a single impartial magistrate will ultimately adjudicate all objections arising from the recount process. Of course, as a general matter, the interpretation of constitutional principles must not be too literal. We must remember that the machinery of government would not work if it were not allowed a little play in its joints. Bain Peanut Company of Texas versus Pinson, decided by Holmes. If it were otherwise, Florida's decision to leave to each county the determination of what balloting system to employ, despite enormous differences in accuracy, might run afoul of equal protection. So too might the similar decisions of the vast majority of state legislators to delegate to total authority certain decisions with respect to voting systems and ballot design. Even assuming that aspects of the remedial scheme might ultimately be found to violate the Equal Protection Clause, I could not subscribe to the majority's disposition of the case, as the majority explicitly holds once a state legislature determines to select electors through a popular vote, the right to have one's vote counted is of constitutional stature. As the majority further acknowledges, Florida law holds that all ballots that reveal the intent of the voter constitute valid votes. Recognizing these principles, the majority nonetheless orders the termination of the contest proceeding before all such votes have been tabulated. Under their own reasoning, the appropriate course of action would be to remand to allow more specific procedures for implementing the legislature's uniform general standard to be established. In the interest of finality, however, the majority effectively orders the disenfranchisement of an unknown number of voters whose ballots reveal their intent and are therefore legal votes under state law, but were for some reason rejected by ballot counting machines. It does so on the basis of the deadline set forth in Title III of the United States Code. But as I have already noted, those provisions merely provide rules of decision for Congress to follow when selecting among conflicting state slates of electors. They do not prohibit a state from counting what the majority concedes to be legal votes until a bona fide winner is determined. Indeed, in 1960, Hawaii appointed 2 slates of electors, and Congress chose to count the one appointed on January 4, 1961, well after the Title III deadline. Thus, nothing prevents the majority, even if properly found an equal protection violation, from ordering relief appropriate to remedy that violation without depriving Florida voters of their right to have their votes counted. As the majority notes, a desire for speed is not a general excuse for ignoring equal protection guarantees. Finally, neither in this case nor in its earlier opinion in Palm Beach County Canvassing Board v. Harris did the Florida Supreme Court make any substantive change in Florida electoral law. Its decisions were rooted in long-established precedent and were consistent with the relevant statutory provisions. Taken as a whole, it did what courts do. It decided the case before it in the light of the legislature's intent to leave no legally cast vote uncounted. In so doing, it relied on the sufficiency of the general intent of the voter standard articulated by the state legislator, coupled with a procedure for ultimate review by an impartial judge to resolve the concern about disparate evaluations of contested ballots. If we assume, as I do, that the members of that court and the judges who would have carried out its mandate are impartial, its decision does not even raise a colorable federal question. What must underlie petitioners' entire federal assault of the Florida election procedures is an unstated lack of confidence in the impartiality and capacity of the state judges who would make the critical decisions if the vote count were to proceed. Otherwise, their positions is wholly without merit. An endorsement of that position by the majority of this court can only lend credence to the most cynical appraisal of the work of judges throughout the land. It is confidence in the men and women who administer the judicial system that is the true backbone of the rule of law. Time will one day heal the wound to that confidence that will be inflicted on today's decision. One thing, however, is certain. Although we may never know with complete certainty the identity of the winner of this year's presidential election, the identity of the loser is perfectly clear. It is the nation's confidence in the judge as an impartial guardian of the rule of law I respectfully dissent. Okay, so the rest of the next 6 pages of Justice's reactions to the majority opinion include a couple different justices that dissent in part of the opinion. So Justice Souter, with whom Justice Breyer joins, and with whom Justice Stevens and Justice Ginsburg join with regard to all but Part C dissenting. As will be clear, I am in substantial agreement with the dissenting opinions of Justice Stevens, Ginsburg, and Breyer. I write separately only to say how straightforward the issue before us really are. There are 3 issues: whether the Supreme Court's interpretation of the statute providing for a contest of the state election result somehow violates Section 5. Whether that court's construction of the state statutory provisions governing contests impermissibly changes a state law from what the state's legislature has provided in violation of Article 2, Section 1, Clause 2 of the National Constitution, and whether the manner of interpreting markings on disputed ballots failing to cause machines to register votes for the president to undervote ballots violates the equal protection or due process guaranteed by the 14th Amendment. None of these issues is difficult to describe or resolve. So, this is 2, whether the court's construction of the state statutory provisions governing contests impermissibly challenges National Constitution, and 3rd, whether there is equal protection violation. So in A, Section 5 issue is not serious. That provision sets certain conditions for treating a state certification of presidential electors as conclusive in the event that a dispute over recognizing those electors must be resolved in the Congress under Section 15 of the United States Code, Title 3. Conclusiveness requires an election under a legal scheme in place before the election, with results determined at least 6 days before the date set for casting electoral votes. But no state is required to conform to Section 5 if it cannot do that for whatever reason. The sanction for failing to satisfy the conditions of Section 5 is simply loss of what has been called its safe harbor, and even that determination is to be made, if made anywhere in the Congress. Alright, letter B of addressing the second issue raised by Souter. The second matter here goes to the state Supreme Court's interpretation of certain terms in the state statute governing election contests. The issue is whether the judgment of the state Supreme Court has displaced the state legislature's provisions for election contests. Is the law, as declared by the court, different from the provisions made by the legislature, to which the national Constitution commits responsibility for determining how each state's presidential electors are chosen? Bush does not, of course, claim that any judicial act interpreting a statute of uncertain meaning is enough to displace the legislative provision and violate Article 2. Statutes require interpretation which does not without more affect the legislative character of a statute within the meaning of the Constitution. What Bush does argue, as I understand the contention, is that the interpretation of the Florida statute was so unreasonable as to transcend the accepted bounds of statutory interpretation to the point of being a non-judicial act and producing new law untethered to the legislative act in question. The starting point for evaluating the claim that the Florida Supreme Court's interpretation effectively rewrote Section 102.168 must be the language of the provision on which Gore relies to show his right to raise this contest, that the previously certified result in Bush's favor was produced by rejection of the number of legal votes sufficient to change or place in doubt the result of the election. None of the state court's interpretations is unreasonable to the point of displacing the legislative enactment quoted. I feel like that's a holding. But there's some numbers that come after that statement. 1 through 3 on this page. 1. The statute does not define a legal vote, the rejection of which may affect the election. The state Supreme Court was therefore required to define it, and in doing that the court looked to another election statute dealing with damaged or defective ballots, which contains a provision that no vote shall be disregarded if there is a clear indication of the intent of the voter as determined by a canvassing board. The court read that objective of looking to the voter's intent as indicating that the legislature probably meant legal vote to mean a vote recorded on a ballot indicating what the voter intended. It is perfectly true that the majority might have chosen a different reading, but even so, there is no constitutional violation in following the majority view. Article 2 is unconcerned with mere disagreements about interpretive merits. The Florida court next interpreted rejection to determine what act in the counting process may be attacked in a contest. Again, the statute does not define the term. The court majority read the word to mean simply a failure to count. That reading is certainly within the bounds of common sense, given the objective to give effect to a voter's intent if that can be determined. So, a different objective to give effect to a voter's intent if that can be determined. A different reading, of course, is possible. The majority might have concluded that rejection should refer to a machine malfunction, or that a ballot should not be treated as rejected in the absence of wrongdoing by elected officials. Lest contests be so easy to claim that every election will end up in one. There is, however, nothing non-judicial in the Florida majority's more hospitable reading. The same is true about the court majority's understanding of the phrase vote sufficient to change or place in doubt the result of the election in Florida, period. The court held that if the uncounted ballots were so numerous that it was reasonably possible that they contained enough legal votes to swing the election, this contest would be authorized by the statute. While the authority might have thought, as the trial judge did, that a probability, not a possibility, would be necessary to justify a contest, the reading is not required by the statute's text, which says nothing about probability. Whatever people of good will and good sense may argue about the merits of Florida court's reading, there is no warrant for saying that it transcends limits of reasonable statutory interpretation to the point of supplanting the statute enacted by the legislature within the meaning of Article 2. In sum, the interpretations of the Florida court raised no substantial question on Article 2. That court engaged in permissible construction in determining that Gore had instituted a contest authorized by the state statute, and it proceeded to direct the trial judge to deal with that contest in the exercise of discretionary powers generously conferred by Florida statute to fashion such orders as he or she deems necessary to ensure that each allegation in the complaint is investigated, examined, or checked to prevent or correct any alleged wrong and to provide any relief appropriate under such circumstances. It is only on the third issue before us that there is a meritorious argument for relief, as the court's per curiam opinion recognizes. It is an issue that might well have been dealt with adequately by the Florida courts if the state proceedings had not been interrupted, and if not disposed of at the state level, it could have been considered by the Congress in an electoral vote dispute. But because the course of state proceedings has been interrupted, time is short, and the issue is before us, I think it's sensible for the court to address it. Petitioners have raised an equal protection claim in the charge that unjustifiably disparate standards are applied in different electoral jurisdictions to otherwise identical facts. It is true that the Equal Protection Clause does not forbid the use of a variety of voting mechanisms within a jurisdiction, even though different mechanisms will have different levels of effectiveness in recording voters' intentions. Local variety can be justified by concerns about cost, the potential value of innovation, and so on. But evidence in the record here suggests that a different order of disparity obtains under rules for determining a voter's intent that have been applied and could continue to be applied to identical types of ballots used in identical brands of machines and exhibiting identical physical characteristics such as hanging or dimpled chads. I can conceive of no legitimate state interest served by the differing treatments of the expression of voters' fundamental rights, the differences appear wholly arbitrary. In deciding what to do about this, we should take account of the fact that electoral votes are due to be cast in 6 days. I would therefore remand the case to the courts of Florida with instructions to establish uniform standards for evaluating the several types of ballots that have prompted different treatments to be applied within the and among counties when passing on such identical ballots in a further recounting or successive recounting that the courts might order. Unlike the majority, I see no warrant for this court to assume that Florida could not possibly comply with this requirement before the date set for the meeting of electors, December 18th. To recount these manually would be a tall order, but before this court stayed the effort to do that, the courts of Florida were ready to do their best to get the job done. There is no justification for denying the state the opportunity to try to count all disputed ballots now. I respectfully dissent. Justice Ginsburg, with whom Justice Stevens joins, and with whom Justice Souter and Justice Breyer join as a part when dissenting. Gonna read this shortly.